Alright Brittney, here's the blunt version while the kettle boils. You jumped into a very public story, did public streams and posts, and, surprise, now the law treats you like a public figure for that topic. That means if you want to win a defamation beef, you need provably false facts, specifics, and real harm, not just, that hurt my brand. This case? The court read it, sighed, and hit the anti-SLAPP button. Translation: commentary about a missing kid investigation on public platforms is protected speech. Lawsuits meant to muzzle that speech get vaporized early, and the bill boomerangs back to the filer. This one was dismissed with prejudice, no takebacks in PA, and the plaintiffs owe the defendants fees, costs, and expenses. Also, RICO isn't glitter you sprinkle on hurt feelings. No enterprise, no crimes, no pattern equals no RICO. And, we'll bring the evidence later, isn't a strategy, it's a shrug. Courts want receipts, on time, in the right format, not a thumb drive of vibes. So what does it mean for you? Keep talking if you want, just keep it smart, label opinions, cite public sources, and skip the, I'll sue you, chest thumping. Courts hate weaponized vibes. This is not legal advice, just the weather report. Bring an umbrella.
Alright Brittney, here's the super simple legal reality check. You can talk about a public case online. If you try to use a lawsuit to shut people up without real, specific proof, anti-SLAPP punts your case, sticks you with their legal bill, and the judge does not send flowers. What the judge basically decided, in human words. This is public issue speech. Missing child case plus YouTube commentary equals protected. Plaintiffs are public or limited purpose public figures. You did media pressers lives, you're not private. That means a higher bar for defamation. The complaint was a mess, rambling, criminal statutes in a civil suit, no timely exhibits, vague quotes, no dates, no who heard what, no actual damages. Anti-SLAPP granted. Case dismissed with prejudice. No PA do-over. And plaintiffs owe defendants fees, costs, expenses. Jointly and severally equals everyone on the hook. What this means for you specifically. 1. You're a public figure here. You went public on this case, so the law treats you like a public figure for this topic. To win defamation you need provably false facts, specifics. Who, what, when, where, an audience actual harm, and for public figures that higher falsity bar. Opinions and insults are not defamation. 2. Shut up lawsuits backfire. Lawsuits meant to muzzle critics are slaps. Anti-SLAPP lets courts kill those early and make you pay them. Say the quiet part, I'll sue to make you pay, and the judge will frame the screenshot. 3. RICO is not glitter for hurt feelings. No real enterprise, no predicate crimes, no pattern. RICO auto fails. Tossing criminal buzzwords into a civil complaint just gets you roasted. 4. Receipts or it didn't happen. We'll bring the evidence later doesn't fly. Hundreds of hours on a thumb drive is not equal to proper exhibits. Missed deadlines plus mystery exhibits equals fee boomerang. 5. Other favorites that faceplant without specifics. IAD needs extreme outrageous conduct plus real impact. Often medical. Online snark is not equal to atrocity. Tortious interference needs named contracts / opportunities and how the defendant wrecked them. Invasion of privacy / false light needs the actual private facts and where they were disclosed. Thinking, we'll just file in another state? With prejudice in PA equals done there. New forums still hit the same walls. Public figure standard, anti-SLAPP risk, fee shifting, and your old filings will be used to check credibility. Forum shopping is not a magic portal. How to stay spicy and safe online. Stick to opinions and clearly labeled commentary on public facts. Link or quote sources. When stating facts, be specific and verifiable. Skip the I'll sue you chest thumping. Courts hate weaponized vibes. Don't name drop lawyers as if they're your counsel unless they are. Keep screenshots and links organized by date, time if you're making factual claims. What to do instead of a doomed lawsuit. Counterspeech, your own stream, video or thread, with sources. Platform tools. Report actual TOS violations. Real-life issues stalking threats? That's police/RO territory. Documented and specific. Bring receipts, not thumb drives of vibes. RICO is not glitter you sprinkle on hurt feelings. If you want silence, buy noise-canceling headphones. Don't sue the internet. Not legal advice, just the blunt translation of what this all means for you.
Here's your takeaway, Brittney, you can be spicy and still be safe. Stick to opinions about public facts, be specific when stating facts, and organize your receipts like you expect a judge to actually read them. If someone drags you online, try counter-speech and platform tools before you try court. Remember, anti-SLAPP protects public discussion. File a gag-style suit and you risk paying for the other side's lawyer. The gavel already fell, with prejudice, fees owed. Lesson learned, keep creating, keep citing, keep it clean. Bring receipts, not thumb drives of vibes. RICO isn't glitter. If you want silence, buy noise-canceling headphones. This has been a dumbed-down summary of Breaking Chain's video for Brittney. Maybe this will help you understand what you've gotten yourself into. Please see the description of this video for the link to Breaking Chain's informative video.